Starting a new job, whether it's your first or a switch from a previous one, brings about exciting changes. You've gone through the whole process of applying, interviewing, and receiving that wonderful job offer. Now there's only one thing left to do: signing the employment contract. It can be nerve-wracking, but don't worry. I'm here to guide you through what you need to know and why you should watch this video before signing a job contract in Germany. Your job contract in Germany is like the roadmap for your professional adventure, holding great importance for both you and your employer. It sets out two key responsibilities. Number one, you have to work and your employer has to pay a salary for that work. Obviously, there are sections and sub-clauses in the contract further defining these two things: salary negotiation and equal pay. When it comes to negotiating your salary, timing is crucial. It's best to have these discussions well before signing your employment contract, as statistics have shown that securing a salary increase later on can be quite challenging. However, there are certain job situations where this approach may not apply. For instance, if you're aiming to apply for a position in the public sector or jobs in a specific tariff, there is no room for salary negotiation. These include the TVL or TVOD contracts and the IG Metall tariff, among many others. When it comes to equal pay, it's a fundamental right for female employees to receive the same compensation as their male counterparts for work of equal value. If men and women in the same role are receiving different wages, it is seen as prohibited discrimination based on gender. It's important to note that just because a male colleague negotiated a higher salary, it doesn't mean a woman in a comparable position should receive less money. However, this assumption can be challenged with valid arguments such as professional experience or training, so please be careful. Minimum wage in Germany. Your boss is legally bound to pay you at least the minimum wage. Exceptions apply for students on thesis positions where a fixed amount of salary is provided, or mandatory internships where employers can even choose not to pay you at all. In all other cases, the minimum wage in Germany is 12.41 euros gross per hour. In addition to your salary, your job contract in Germany also contains specific information on start and end of your contract, like is it a permanent contract or for a specific time period, place of work, like is the job on-site or is there a hybrid model. In the case of hybrid models, what are the tools provided to you for your home office, the weekly or monthly working hours, vacation details, and most importantly, the probation and notice periods. I will discuss all of these points in detail later on in the video. Before that, I want to discuss something most expats in Germany struggle with. Is a written job contract required in Germany? Usually, an employment contract is used to formalize a job, although it may not be always legally necessary. Surprisingly, you can sign an employment contract through various means, including email or a digital signature. In fact, you can even agree verbally. However, if your employer fails to provide you with a written contract, they are still obliged to give you something in writing. This document should outline the essential terms and conditions of your employment, accompanied by your employer's signature. It's crucial for your employer to meet this requirement because in case of any disputes, they will need to prove in court the oral agreements they made with you. The document must have information provided under the Evidence Act and must be given to employees in a written form, not just through email. It should include the employer's or authorized representative's signature. Failure to meet these requirements can lead to fines for the employer. For fixed-term employment contracts, written form is always required. An oral agreement for a fixed-term contract is not legally valid. Both parties must physically sign the contract by hand. A digital signature is not sufficient for a fixed-term employment agreement. Here, having legal help can save you a lot of headache. I'll put my favorite legal insurance in the description below. Job description and performance exceptions. When it comes to your employment contract, it must not provide the details of every single thing that you have to do. The broader the description of your responsibilities, the more flexibility your employer has in assigning you different tasks. On the other hand, a more detailed job title and description make it easier for you to decline tasks that are not aligned with your qualifications. It's beneficial to have a general job designation like engineer clearly specified in the contract. You can take cues from the job advertisement to get a better description of your position. Under the guidelines of the Evidence Act, it's important that a concise written description of the work you'll be performing is included. It's worth noting that your employer cannot unilaterally assign you a lower paid position. As an employee, you are not obliged to achieve specific work outcomes. Instead, your responsibility is to perform the best of your abilities under reasonable conditions. If your employer is dissatisfied with your performance, they may consider termination based on behavior or personal grounds. However, they must provide evidence that your performance has been significantly inferior compared to an average employee with similar tasks over an extended period. If you're getting value from this video, please hit the like button and consider subscribing. Place of work. Your primary place of work is where you'll be performing most of your duties. Usually this means working at your employer's premises. However, your employment contract may provide opportunities to work in various locations, including different cities, countries, or even other branches of the company. If you have any concerns or preferences about your work, it's important to discuss them openly with your employer and engage in negotiations. According to the Evidence Act, the place of work should be documented in writing. If you're not tied to a specific location, the contract should indicate that you have the flexibility to work in different places or even choose your own place of work. Suppose you want to work from home for a certain number of days each week. In that case, it's advisable to include this agreement in your employment contract. The contract should clearly state that you have the option to perform your work from a home office and should specify the number of days that you are allowed for remote work. Paid vacation in Germany. Your job contract typically specifies the number of vacation days you receive each year. According to the Federal Holiday Act, the minimum requirement is at least 20 working days for a 5-day week. However, it's quite common to have 30 days or even more. In fact, some employers may even offer additional vacation days that increase as your stay with the company increases. The good news is that negotiating for extra vacation days is a possibility, allowing you to potentially exceed the legal minimum. If you work part-time, you can be entitled to the same number of vacation days as colleagues who work full-time, but you have to work every working day of the week. So it's not just the hours that matter, but the days. Anyone who works 20 hours a week does not automatically have half the vacation days as a full-time employee. According to the Federal Holiday Act, your full entitlement to vacation days kicks in 6 months after starting a new job. As a new employee, you start acquiring vacation entitlement during the probation period, specifically 1/12 of the annual vacation for each month. Permanent and temporary job contracts. When it comes to employment contracts, having a permanent one is usually better than a fixed-term contract. However, there are certain industries and employers that often offer temporary positions to new hires. Temporary contracts. Temporary contracts have a specific duration mentioned on them. They are commonly used when there is a valid reason, like covering for an employee on parental leave. This type of contract allows flexibility for the employers to fill in short-term staffing needs. Fixed-term contracts. If your employment contract has a limited duration, it's usually accepted if there's an objective reason behind it. For example, filling in for someone on leave or assisting on a temporary project. These reasons justify the use of a fixed-term contract. In cases where there isn't an objective reason for a fixed-term contract, it can typically last up to 2 years. This time frame provides more flexibility for employers in managing their workforce. After the contract ends, employers may reconsider and offer a permanent position if the circumstances allow. For example, some companies have an option where they can only extend a job contract for 2 times. The third time, they have to give a permanent contract. Part-time work. Working fewer hours than full-time colleagues makes you a part-time employee. It's important to clearly specify your weekly hours in your contract, especially if you need to balance work with family, sports, or studies. Part-time employees in Germany generally receive the same treatment as full-time employees, including legal protection and benefits. Probation period in Germany. When you start a new job, there's usually a probation period mentioned in your contract. It's like a trial period for both you and your employer to see if the job is a good fit. For example, the first 6 months of your job are generally considered the probation period. During this time, either you or your employer can end the contract by giving a 2 weeks notice. If your contract doesn't talk about probationary period, it means that you don't have one, and your employment starts right away. Some contracts have a smaller probation period of 3 months, and some job contracts even have a clause that extends the probation period. An extension of the probation period is generally possible with the consent of the employee, but it is legally ineffective. Despite extending the probationary period, the employer can only terminate the contract with 4 weeks notice. In addition, the employee is always protected by the Dismissal Protection Act after 6 months, even if the probationary period has been extended. This means that your employer can no longer end the employment relationship so easily. However, there are cases where your employer can terminate your job contract without the notice period even after the probation period is over, which I discussed in this video. So thanks for watching, bleib gesund, and I'll see you in this video.